Well, thank you, everyone, and thank you for having me. Oh, this is quite a mic for this size room. Packs plenty of punch. So we have, do I understand we finish at 4:30, right? Which means, okay, I'm not going to hold out on you. We will finish right on time. This is the ethics portion of your presentation, so we're going to accomplish some of that. And so I have some scenarios to go through, as well as I thought I'd give you an update on the some things that are happening in the discipline system and how it works. But then I thought I'm hoping to save at least 15 minutes at the end just for some Q&A. If you have questions about any of the material or how we do things, I think all of that qualifies as ethics of some sort. So I'm happy to answer any questions you have about the things that we do. Let me start by saying how I got involved in attorney discipline. And no, it was not because somebody turned me into the bar and I had my own case. I have to say that when I was in private practice, I paid very little attention to attorney discipline. I was not one of those people who flipped to the back of the bar news to see what happened to anybody. The only time I ever paid any attention if a situation became notorious, and we had a few of those in Spokane. And so they were cases that your general reaction, if the person was disbarred, was duh, those kind of cases. So I really didn't have an appreciation for the way lawyer discipline works in Washington until I became a justice. Because suddenly, one of the many parts of my job that you have zero training for when you become a justice is that we administer the attorney discipline system. We are the oversight of the bar, and particularly the regulatory function of the bar. Of course, we're also the rule drafting and rule adopting entity of the judicial branch. And so during my time on the court, we've done a pretty thorough revision to the rules of professional conduct as well as to the code of judicial conduct. And some of those debates were absolutely fascinating. I mean, just as an instance, in the major revisions to the code of judicial conduct, whether appearance of fairness would remain as a code violation was hotly debated among those who advocated for us and even among those on the court. And the view that prevailed was one I strongly adhere to, which is that I believe for the public's trust and confidence in the justice system, the violation of the appearance of fairness is every bit as important in my view as actual unfairness, because how we're perceived to be has a lot to do with the delivery of justice. So coming into this system as an outsider, let me just share with you some of what I've learned, which I think is really important for all of us who practice in various aspects of a justice system need to know. The first is we're really, the legal profession is the only professionally licensed field of occupation that regulates itself entirely. So that's a delicate balance. In part, it's a delicate balance because if you have followed like the North Carolina Dental Board case that went through the United States Supreme Court just a year and a half ago, you recognize that a self-regulating license admission-based profession faces antitrust concerns for being anti-competitive, not just in how we bring people into the profession, but also how we regulate them. And so there are always concerns about the proper degree of oversight and the fairness of the rules and who is doing the review to make sure that lawyer discipline doesn't become a barrier to fair competition, or that the regulation of the unlicensed practice of law does not become a barrier to competition. So I think when you look at how the discipline system is structured, some of what we do in our state is to make sure that we have oversight by the Supreme Court rather than just the members of the bar in administering lawyer discipline. The second thing that I was entirely unaware of until I got involved at this level, is how much goes into working with a lawyer who's having issues before a case becomes a discipline case. And how, sadly, some cases that result ultimately in disbarment probably never should have resulted in disbarment. It's simply that a person refused to cooperate in the investigation or work towards some remedial type of services. And so something that might have just been a short-term suspension, that level of conduct can escalate to much more severe discipline just based on pure non-cooperation. And in a couple of the most egregious cases we've seen, lawyers who might have faced maybe a 6-month suspension were disbarred when their conduct just cost all of us, thousands and thousands of dollars by doing things like, for instance, one lawyer who was subject to discipline would go to the bar office and at the 11th hour serve papers explaining why he was refusing to come to the bar office for a deposition because he wasn't being paid his travel to come to the bar office. And then he would leave and not show up for the deposition. It would have to be rescheduled, and this went over and over. And conduct like that just makes it impossible for us to regulate ourselves as a profession if we can't agree as a matter of professionalism to participate in the oversight. So when cases now come in front of me, the Supreme Court does not directly look at every discipline case. So if someone receives a reprimand or an admonishment, we see notices of those, but those do not directly come in front of the court. We do, however, have to look at some level, even on a sua sponte review, any case that recommends disbarment, and then any case that's appealed from a suspension. They have a right, there's a process, I won't bore you with the details, but there's a fair amount of due process built into that. And we, in addition, even have to approve any stipulated discipline. So the bar and the respondent lawyer might agree about an appropriate level of discipline. And in numerous instances, since I have been on the court, we have pushed back and said this doesn't seem proportionate to what happened in this case. Explain to us the differences. This looks like a disbarment situation. That's what happened in these 4 other cases. Why is it a 2-year suspension recommendation? So we haven't always accepted that simply because it was a matter of a settlement. You can't just settle these things because they're in the public interest, and that's why we have that oversight. So let me pause and ask, any general questions just been about that discipline system before we dive into looking at a few cases? All right, so I'm driving my own ship here. Let's see if already we're going the wrong direction. Okay. So the way this is set up is you have to decide these cases, okay? I realize you have the cheat sheet. I'm encouraging you to just hide that at the moment. And let's just think through these. Actually, let me give you a couple of ground rules. First of all, put the cheat sheet away. Okay, that's ground rule number 1. Full disclosure, it doesn't give you a lot of detail. It gives you this, it doesn't really discuss all the grounds for the actual discipline that was imposed. The second ground rule is, I don't care if you know the RPC number of the violation at issue. I don't know the RPC number of the violation at issue unless I remind myself. A few you kind of commit to memory. Like if it's some kind of falsehood, lying to a court, or misconduct, or committing a crime, we know that's sort of 8.4-ish. That one kind of sits there. But for the most part, I don't know the numbers, and I don't care if you know the numbers. We'll just talk about what did the person do that got the person in trouble. Okay, so those are the only ground rules. Participate enthusiastically. If you disagree with someone's recommendation, we'll debate that out. I can tell you we do that in conference with great enthusiasm, so I encourage you to do the same. And as we say in my world, where the 9 of us, we try to agree as a group of 9, but we find it sometimes even hard to count to 5 among a group of 9. But we always proclaim that we can disagree without being disagreeable. So disagreement is not a bad thing. All right, case number one. So I'll give you the setup. So Johnny, we're going to call our respondent Johnny Jr. He lived with his mother in the family home, and he also operated his law office out of a room in that home. Then his mother passed away, and in her will, she left the entire estate to 4 brothers, Johnny Jr. among them, to be divided equally. And Junior, you all know how this is, as the lawyer in the family was named the personal representative. So immediately he refused to give his brothers copies of the will, nor would he give them any information about the value of the home. And he continued to live in the home without charging himself rent, but he paid the taxes and the utilities out of the estate. He then deeded the family home to himself, but he didn't tell his brothers, nor did he record the deed. The brothers grew increasingly concerned, and they hired an attorney. He refused to provide the attorney with any information about the estate or its accounts. 3 years later, the matter finally went to court, and in the ensuing litigation, which lasted another 6 years, Johnny Jr. made some false claims. He gave some incorrect information, including under oath. He also continued to refuse to produce any real estate documents about the home. So the trial judge removed him as a personal representative and set aside the attempted unrecorded deed of the house to himself, and then ultimately ordered that Junior reimburse his brothers for rent and other expenses. So the case comes, the discipline case then comes to the Washington State Supreme Court. I'm sorry, actually, I'm getting ahead of myself. The underlying estate dispute came to the Supreme Court, and we affirmed the trial court. Then for the next few years, Junior repeatedly filed various motions and lawsuits trying to collaterally attack the trial court's orders. And these were ultimately determined to be frivolous, and sanctions totaling about $140,000 were imposed. He was on a few occasions held in contempt of court for failing to provide documents. Oops, I got it. Well, duh. Okay, this is one of those duh cases, right? So no one should be surprised. But let's pause and say, okay, so what do you think? Let's go back to phase 1. Was it a problem for him to be the personal representative of the estate? No, that's not a problem. Though if you have a transaction with a non-family member client, and you write the will, you don't want to make yourself personal representative of the will, and you certainly don't want to be a personal representative of a will that you're a taker under when it's a non-family member, even if you didn't write the will. But that in and of itself is not a problem. He lived in the home. Is that a problem? I'm seeing equivocation. Does anybody think it was a problem that he continued to live in the home? Excuse me. Okay, people are saying rent. Well, I totally agree. I think not a problem to continue to live in the home. It's where he lived before. But in fairness, as a fiduciary, he wasn't paying rent. Okay. What about not giving the brothers a copy of the will or the real estate appraisal? Sorry. Yeah. In what capacity is he refusing to do that?
PR.
Right? Yeah, he's the PR. So he's got a fiduciary capacity. That is a problem. And as a lawyer operating as a fiduciary, he's clearly subject to the rules. So fairness to the other parties, but also just full disclosure to folks who are beneficiaries under the will would mandate that he provide that information. Okay, so we already know some violations, right? So just fairness and full disclosure, keeping folks informed. What about conflict of interest? Do you think he at this point was in a conflict of interest? Anybody think so? Yeah, I think he was. I mean, that wasn't the heart of it, but it's a little subtle, right? Being a beneficiary under the will, living in the home, that doesn't automatically give you a conflict of interest. But I'm sorry about this. Once his interests and his brother's interests started to clash, it was clear that he was self-dealing. right? And so that just automatically gives rise to a conflict of interest. I think that can be a subtle one, though, because any will disputes that involve a family member lawyer who gets to be the PR, which is most families that have a lawyer in them, we're going to see some tension in how folks think things ought to be carried out. That doesn't automatically mean there's a conflict of interest, but this one clearly rose to that level, given his fiduciary capacity. All right, well then they all go to court, right? So the brothers lawyer up, they go to court and fight this out. What else did he do wrong then? All right, somebody over here, say it again.
I said, oops, he forgot to provide the documents to the lawyer.
Yeah, so there's some withholding of information, which is candor to the tribunal as well as fairness to opposing party. One more basic one.
He recorded the deed in his own name.
Yeah, well, he didn't record the deed.
Well,
Yeah,
he
yeah.
didn't record it, but he actually put it in his name.
Some pretty direct self-dealing. Yeah, back there.
He paid he used the state money for his own use.
Right, total conflict of interest, using self-dealing by using the estate's money for his own use. I mean, you may know, we see this frequently in will disputes, that when a person is misusing that money, even individually, they should be responsible for the attorney's fees. And so frequently, people are even, and he was too, paying the attorney's fees for fighting the brothers out of the estate money as well, just using it kind of like his own account. What's a really basic thing he did? So anytime you're a lawyer and you're litigating in court, you have an obligation to be expeditious and diligent and raise meritorious claims. So even just that level of misconduct got him in trouble here too. So he probably could have been disbarred 10 times over for all the conduct that went on here. And you can read the whole sordid story in discipline proceedings against Jones. Yeah. And I have to say, these cases I find, this is, they're just sad cases because the discipline problem was just the tip of the iceberg, right? This was a decade of fighting and wasting away the resources that were left behind. So I wish I could say that's unusual in will contest kind of cases, but maybe it is. It's not unusual in the ones I see, but if I see them, it's not going well anyway. All right, let's go to Frank Fiduciary. Okay, so we start out knowing he did something wrong. He misused his lawyer's trust account. He didn't keep adequate records on the account. He didn't put all the client funds in the trust account. He kind of shaded with the client about how much he really had to do with the trust account. And then when he was running short, he just borrowed a little from the trust account and didn't quite maintain discrete records between his business expenses and the trust account. Eventually, his mismanagement of the trust account came to the attention of the State Bar Association because he was repeatedly overdrawn. You may know this, just pause a moment. The Bar Association, as a condition of your license, you are subject to random audits, or any lawyer, practicing lawyer, is subject to random audits of his or her trust account. This was not a random audit, though. Whenever there is suspicious activity, there can be, with due process protections, a targeted review of that account. And this was one of those targeted investigations. So during that investigation, Frank misled the WISBA about his management of the trust, and he did so in writing. And I love it. He actually said, well, the letter is different than, the facts. This is, the reason I include this case is that the number one issue that results in attorney discipline is mismanagement of trust accounts. I would say the vast majority of the time, the mismanagement is negligent and just sloppy. And what Frank Fiduciary said here is what we hear from a majority of attorneys who get in trouble, which is, well, my assistant, kind of was managing that, or I didn't quite have, the bank wasn't being diligent in giving me the information I needed. But the lawyer is the ultimately responsible person for the account. This, of course, went beyond mere negligence, and the discipline that results requires more than mere negligence. There has to be knowing, willful, willfulness is a debated term in the discipline world, but certainly it has to be knowing. You have to know that you're doing something that crosses the line, and I think that definitely happened here. So let me ask about this. Well, first of all, okay, so as to the trust mismanagement, what about using the trust account for overlapping expenses for just a short period of time? Okay, I'm saying for being very new. Yeah, okay, well, good. I've been at some county bars where we talk about this one, they're like, well, let's just tell the check clears, you're gonna get right back. No, it's never, ever okay. The bigger problem though, and so we'll give away the punchline here, 2-year suspension. There were some mitigating circumstances here involving some personal issues that were mitigating, also full cooperation eventually, that made this a 2-year suspension case instead of a disbarment case. But I think that's pretty typical. Very little client fund mismanagement that doesn't result in permanent harm to the client or harm to the client won't generally be a disbarment situation. It should be an easy situation to avoid, but if there's not financial damage and the situation can be rectified, it's much more common that these will be suspension cases. And you know, do people know what disbarment means in practical terms? If you were to equate disbarment to a suspension, what is it? It's a 5-year suspension. Okay. In a sense. Disbarment is permanent in the sense that a person who is disbarred has to reapply, has to retake the bar, and has to show good character going forward. But anybody who is disbarred is eligible to do that upon the expiration of 5 years of the disbarment. So in terms of the effect on someone's practice, a 2-year suspension is a serious sanction. You know, that for all practical purposes shuts a person down and requires some other form of livelihood. So this was a very serious suspension. I don't think the court, for the most part, a 3-year suspension has occasionally been handed out when there are aggravating circumstances, more to send a message. The presumptive sanction under the American Bar Association guidelines for attorney discipline, does anybody know what that is? So for suspendable misconduct, the presumption is if there aren't any aggravating circumstances and there aren't any mitigating circumstances, it should be 6 months. That's the presumptive amount. So 2 years is a, pretty significant suspension. I want to recommend to you, it's not in my materials, but there was a fairly notorious in the 70s and since then well-known lawyer because he spoke a lot at CLE's, Washington lawyer named Eagle Bud Crow, Krogh, okay, who got mixed up in the Watergate stuff and the Pentagon Papers, and he was sent to federal prison for his involvement in the Pentagon Papers. He was disbarred from the Washington bar. And I really recommend reading his, he twice had to seek readmission, was denied the first time, and I think Justice Utter wrote a dissent to that decision, and then later, many years later, was readmitted to the bar. And they're really interesting cases to read, just to see kind of the arc of what it means for the good of the order, for the individual, etc. I have to say, I had a chance, many of you I think do know him, and I've had a chance to be on CLEs with him, and just to hear him talk about it, he was quite young. My law clerks, the first time I heard him speak, attended the presentation, and both were just struck. They were brand new lawyers. They said it was the best ethics presentation they ever saw, because his theme was, here's the crazy situation, I'm the junior lawyer in the room, and here's what's going on, what should I have done? And then it was, well, here's what I did do. And we could all see ourselves in that situation. You know, I'm sitting here with Richard Nixon and senior White House counsel, and I'm going to speak up. Well, yeah, you have to. And, you know, but it was really powerful because I think it just drove home the point about personal responsibility and personal integrity. And he was, you know, 29 years old with preschool-age children when his wife heard on the news, driving home from work, that he had been convicted and was going to federal prison. You know, and that's, you know, a pretty big lesson to pay for not wanting to be the uppity young associate. So it was pretty powerful. All right, let's go to neglectful Neil. I think, no, that's right, we did change it. This time, we have, over the course of these materials, this person's name has been changed. So I was making sure we didn't, it's in your materials as neglectful Neil. All right, so Neil was hired by a family that had been in a car accident. He didn't immediately file suit until just a few days before the statute of limitations expired. And then he didn't really do any discovery, nor did he prepare any potential witnesses to testify. And the court deadlines were sort of coming and going. And the case was dismissed for non-prosecution. But he didn't really want to tell his client about that. Nor did he communicate a settlement offer. It wasn't a great settlement offer, but there was a settlement offer, and he didn't really tell his client about that. And then he decided he wasn't doing a very good job and he should just withdraw. And he didn't give his client notice of that. And so as a result of this culmination, there was a viable settlement offer, but the statute of limitations expired and the claim was never preserved. So let's pause and talk about this. Did anyone in this room ever do personal injury work? Okay, I did, and I worked for the trialers. Is there anything wrong with waiting until just before the statute of limitations to file a claim? Those of you who've done personal injury work. Good, I'm glad to see that. Of course there isn't. You know, you want the case as mature as it can possibly be before you file. So that's, you know, I find when I talk to many people, they say, well, that was his first mistake. You know, you should file at the soonest opportunity. Well, that's not good advice for people who tend to handle personal injury claims. Okay, so that's not a big problem. What do you think is the general theme, perhaps indicated by his name? What would be a word in the RPCs that might come to mind? Like diligence. Yes, Neil was not diligent in prosecuting the claim. So I don't think I would read the waiting until before the statute, a few days before the statute, to do anything. But not performing discovery, clearly not diligent. Not preparing witnesses for their testimony, clearly not diligent. What else got him in trouble here? Yeah, diligence. I'd say the missed deadlines are coming on the same diligence theme. But yeah, someone mentions the settlement offer. What about that? What's he doing wrong here? Yeah, non-communication. I mean, the client is in the driver's seat. Even if it's not a very viable settlement offer, the client has the opportunity to review it and make the decision. So it's absolutely critical that the client be informed of all the steps in the litigation, and he wasn't doing that. What about withdrawal? Withdrawal is always a tough one. Has anyone in this room ever had to withdraw from a representation? Yeah, okay. It's tough, right? So what are your obligations at the time you decide to withdraw? Yeah, you've got to, yeah, the rule is crystal clear that you have to give notice and you can't withdraw under circumstances that prejudice your client's interests, right? I mean, if your client is, there are some extremes where you can advise the court and take steps if your client is insisting on that you suborn perjury or something, you know, it might have to just happen mid-trial. But for the most part, if it prejudices your client's interest, you have to take steps to safeguard your client's interests in the course of withdrawing. At a minimum, we're not even close here because he immediately withdrew without any advance notice or opportunity for the client's interest to be protected. So what do we think happened? What do you think happened to Neil?
He got sued for malpractice.
He might have gotten sued for malpractice, yeah. Though let me pause there and say, you know, that's such a toughie, because all the misconduct in the world is not malpractice, because you still have to show your case within a case. So if the case wasn't that great, but here, of course, there's a settlement offer on the table, so you're at least worth that if he doesn't communicate the settlement offer. But yeah. 6 months suspension, and ordered to pay restitution, which was the amount of the settlement offer that was never conveyed. I mentioned that 6 months, I've got some notes on him. 6 months is the presumptive suspension. So what that means in the context of this case is that there were equally balanced aggravating or mitigating circumstances, and the case came out sort of neutral. So mitigating could be, of course, he paid full restitution, so the client was put in the same position that the settlement offer would have put the client in, and that was certainly a motivating factor in that case. All right, speaking of withdrawal, let's look at really withdrawal. We'll just read the facts and you'll see your heart goes out a little bit to Willie Withdraw. Represented a difficult client in the personal injury case. They had some personality conflicts, and so Willie withdrew from the case. The client settled on her own, but the checks that were then issued were issued in both names, very common, in the lawyer's name and the client's name. He didn't want to charge her a fee because he had withdrawn, but he thought he was entitled to recover $1,500 in expenses that he had advanced. So the client wanted an agreement that $1,500 was the sole amount that the client would owe to Willie. And so he negotiated with the client that that agreement would be fine if the client also agreed to release all the claims she might have against him. And she did that and signed the agreement. Okay, so this is well, let's pause. The withdrawal itself, any problem with the withdrawal? Right, no, there's, notice was given, no prejudice to the client under the circumstances of the case, so he's fine to withdraw. What about insisting that he be allowed to recover, what is this, quantum merit, his expenses that he had paid in the case? Any problem with that? No problem with that. You're absolutely entitled to seek reimbursement for what you've put out in the case. So what did he do that was not okay? Right, so he's entering into a contract with his own client. So at a minimum, what does he need to tell that client? Yeah, he absolutely was required to advise the client that she should seek independent counsel, that this is an adversarial relationship that they're now in, that he is asking her to settle any future potential claims against him. Actually, he's not even the one in the position to advise her about all those things. His obligation is to tell her, we're in an adversarial position here. We're like parties to a lawsuit on opposite sides, and so you need to get independent advice, and I'll give you X, you've got to give a person a reasonable opportunity to do that. And that was not done here. Well, I actually gave you an RPC number here. I didn't realize that. Wow, 1.8. Okay, so the notice is supposed to be in writing to seek independent advice. And this one was also the presumptive amount of the sanction, which is 6 months. There's a case, and I'm not remembering the name of it, it's in your materials, that was a similar thing where the lawyer didn't advise, there were two parties to a prenuptial, and the lawyer needed to advise the disfavored party similarly. It's not the same RPC, but just advice that he couldn't represent both of them and that she needed independent counsel. Clear malpractice when you don't advise someone of that. But it has a similar conflict of interest type of failing. This is more direct because the contract that's at issue is not one between clients you shouldn't be co-representing, but one between yourself and the client. All right, let's go to case number 5. Peter Protector. We gave him a second name, which will become obvious in a minute. Ned No Canuck. He had a discipline history. So he'd been disciplined a year prior to this and was suspended for 18 months. 30 years prior, he had been disbarred, but for gun violence, but he'd been readmitted and had been a lawyer for a while now. So this litigation that got involved concerned his wife's chiropractic office and a dispute with an employee in that office. Oh, I realized this was a hearing officer. Maybe one of you heard this case with the employment dispute with the former employee who was Canadian, which is the no Canuck thing. So the findings, this case is kind of entertaining to read, but the hearing officer found that Peter intentionally and repeatedly obstructed and delayed the litigation by failing to respond to discovery requests. Some of this included the kind of conduct I was describing earlier that we've seen from some lawyers, where he would have responses prepared but refused to deliver them until something else was done. It just protracted and drove up the expenses of the litigation. He also falsely swore that he had, he signed the document saying he had inquired into the accuracy of the responses, which he had not done, and they were completely inaccurate, especially revealing the value of the assets of the wife's business when in response to those questions and interrogatories. So the obstruction delay tactics continued when the person who was suing them, the former employee, then later tried to collect the judgment. Okay, so what happens then? Then he decides, he's a good lawyer, actually, he's an excellent lawyer, that he's going to set up a scheme where all of his wife's assets are going to be owed in legal fees to his firm, and that he can shield the personal and community funds from creditors by putting them into his client's trust account, which had the de facto effect of making the trust account his own personal account because it was full of his fees. And then his wife went bankrupt to avoid the judgment. And he provided the bankruptcy filings. He also represented her in the bankruptcy proceedings with numerous omissions and misstatements. And he was, by the bankruptcy court, he was sanctioned and disallowed from further representation of his wife in those proceedings. Let's start at the top. What do you think happened to him? 6 months suspension? No, this one got a little more serious, yes. So no big surprise. He was disbarred. I give you the other cases there too. The 98 Washington 2nd case from 1982 is the shooting, the firearms case that resulted in his first disbarment. But among the many things he did wrong, which obviously included lying to a tribunal, not just lack of candor, but filing false reports, self-dealing, misuse of the trust account. But there's a general catch-all for conduct prejudicial to the administration of justice. And this was actually a somewhat serious account because he had he sent ex parte a letter to the judge in the underlying tort employment dispute case that was improper, right? He's the attorney in the case, you shouldn't be sending ex parte letters to the judge. But then he essentially says, who are you gonna believe? My flag-waving American wife or this dirty Canadian who's just coming across the border to take jobs away from Americans. So the court found that particularly prejudicial to a lot of things about the administration of justice. To the best, so when did that last disbarment was in 2013, so he's eligible next year to haven't seen anything yet. All right, Frankie Fix-It. This is a case you may have heard about. It was somewhat well publicized at the time. He's a criminal defense attorney in Skagit County, focusing on DUI cases. He worked out a plea agreement for a client to reduce the charges down to a first-degree negligent driving, but he didn't specifically request the suppression of the breath test. Okay, you're all hearing examiners here, right? Do any of you do the license suspension stuff? You know, there's parallel licensing proceedings, obviously, and DUI proceedings going on. So this was kind of a big miss. You want to suppress the breath test results so when you get to the licensing proceeding. But later that day, then he was on the phone with the Department of Licensing representing his client. He, of course, knew that a suppression order would have prevented the 90-day automatic license suspension. So he told the DOL officer hearing officer on the phone that he had the suppression order. And she said, okay, send that right over and we'll be good to go. So then he's in a quandary because he doesn't have the suppression order. And backdrop to this, everybody agrees in this case. The judge who was at issue, the prosecutor on the other side, and Frankie Fixit, everybody agrees that had he asked the judge to suppress the breath results, the judge would have suppressed the breath results as part of this deal. But, you know, it's like 4 o'clock. She wants it back that day, so he decides to fix it. So he goes to the clerk's office and asks to see a copy of the judge's order. And he steps away from the counter and he goes over to like a side counter and he writes in BAC suppressed, not a knowing involuntary decision to take the test. He writes that on the order that's already been signed by the judge. Then he takes it back to the counter and asks the clerk to run a photocopy. But the clerk saw and refuses to do so, and she contacts the supervisor who contacts the prosecuting attorney. After a conversation with the prosecuting attorney, they agreed that they could stipulate to this, that wasn't the right way to handle it, but they could just stipulate to get it handled that way. Pause and think, I mean, this is small town lawyering. I mean, I can see them all trying to be collegial. But at some point, somebody knocks on the judge's door and says, hey, judge, this whole thing just happened, but it's okay, they're going to stipulate to it. And to his credit, the judge is the one who reports the misconduct to the Bar Association and says, yes, I would have absolutely done this, but you don't alter court records. And he files, the judge files the grievance with the Bar Association.
What happened to the prosecuting attorney?
Yeah.
Very good question. So, you know, it's funny because at the time we heard this case, there was nothing about the prosecuting attorney. Somebody asked that question since then, and I'm not aware of any grievance being filed against the prosecuting attorney. There may have been, you know, sometimes if there's an admonition, there may have been something that just never made its way into the public reporting. I would hope so, because I think both of them were in the wrong by thinking they could just sweep this under the rug. But there was never any public discipline about the prosecuting attorney. So, what do you think? Anybody not think disbarred? Okay, a couple. Well, let me give you the punchline first, because as a matter of fact, he was disbarred. It was not a unanimous decision. There was no prior discipline history. The attorney had an excellent reputation in the community. The biggest factor, and this gives me an opportunity to talk about, frankly, how inconsistent these cases are. Probably the biggest factor that resulted in this attorney being disbarred, where other attorneys, and I'll talk about a couple of these, I'll give you the details, were not disbarred, was significant experience in the practice of law. I mean, you see it as a leader, it was a 20-year lawyer, and so the gee, I didn't, you know, gee, I've learned my lesson, I won't do it again, was harder to buy after 20 years. But it was a case the court struggled with, because this wasn't somebody who was trying to, you know, self-deal or mistreat his clients. It was just a really stupid thing to do and try to cover up. Some of the cases that gave us pause, there's a case involving a young associate at a larger law firm, this case is maybe 10 years ago, who failed to file something, I can't remember if it was service, some very time-sensitive document. And realizing that she hadn't done it when she should have, she backdated it and forged a notary seal and then attached it to the pleading that went out. And then she tried to cover it up until it became obvious what she had done. That attorney received a 6-month suspension. One of the points of discussion in this CAM case distinguishing that is that was pretty awful, but there were significant mitigating circumstances and inexperience, and also it wasn't a court, it wasn't going to the clerk's office and pulling a court order that a judge had signed, so it wasn't the tribunal. Yes, ma'am.
I'm with the Department of Licensing. This was not specifically my case, but a few years earlier, he did something similar to me. He said he had a suppression order, and then I found out it wasn't the case after the fact.
That he hadn't. No, that's interesting.
He asked
That-
for collateral estoppel to be applied.
And that was not in our record, I can say that. So I'm assuming in that case, they did go back and get it, but at the time he said something in the hearing, maybe he
But
didn't
he
have it,
actually
but then he got
presented me
it.
with an order,
Hmm.
and I found that it really was
Oh.
not the way he represented it. But anyway.
Yeah, interesting,
But
yeah.
after that, it was like, everything he said after that, it was like, I
Interesting.
don't really, it was harder for me to believe him after that. I will admit, I did not contact the Bar Association and say, this attorney, I didn't do that.
Yeah. Well, we'll come back to that. 'Cause, yeah, question here.
How do you hear these cases? I mean, when they get to you, is it full on?
Good question. How do we hear these cases? It varies. This case was full oral argument. Yeah, we had, so anytime there's a full appeal from a disbarment, where the action at the bar level is disbarment, we will hear the case if they ask for oral argument. Occasionally they waive. This person was represented by counsel, but we hear certain cases. We hear almost huge number of interim suspension cases. People waive argument, and sometimes they advocate without counsel, pro se. And so, but this case was a full oral argument, and we write a full opinion. Yeah, all of the ones I'm telling you about were, except for one at the end, were full oral argument. Yeah. I want to come back to this, what should you report when you see it? And there is an RPC, I don't remember the number, it's down low, I have it here, I can follow it, that talks about reporting misconduct. And you don't have an obligation to do that, which I'm really glad about. I have to say that just for the good of the bar, I think there's there's a need for that you don't want people getting in trouble for non-reporting in circumstances that may be discretionary. I think there is some people, so it just depends on your sense of professionalism about what is good in the situation. But that was another issue that we hotly debated when we were looking at the revisions to the RPCs, and that I know the ABA was really torn on is when is the mandatory reporting requirement that would then subject a judicial officer or another attorney to discipline for not reporting. And those are very, very limited circumstances. Yeah. All right, let's move on to case number 7, Norma No Fight. So this was someone who represented a client who's detained on an immigration hold, and the judge denied the client's application for asylum. Norma failed to timely appeal to the Board of Immigration Appeals, thus subjecting her client to immediate deportation. So then her client is arrested by ICE, and she panics. She contacts another firm to handle the appeal on behalf of her client. So Felicity Forger, an associate in the firm, is tasked with the assignment because the partner that they had hired was going to be out of town. So Felicity drafts the appropriate motion for the acceptance of a late appeal, basing it on Norma's ineffective assistance of counsel. She submits it along with a declaration by the client and her own notice of appearance to the Board of Immigration Appeals. In fact, Felicity had never met with the client, who was in custody. The appeal was denied, and then the law firm sent a copy of the decision with a letter stating that the firm didn't actually represent the client, but was only assisting Norma with the appeal, and therefore the client would have to get another lawyer to further appeal to the Ninth Circuit. So then the client retains Darla Duguid, who performed her due diligence and found further discrepancies in the file. Her investigation showed that the client had never met with Felicity Forger, despite the submission of signed client declarations to the BIA. Darla reports she files a grievance with WISBA concerning Felicity's representation. And upon questioning, Felicity says, well, I did visit the client, and the client did sign these declarations in my presence. And the backstory of that, every time you visit an immigration facility, there's a sign-in log. And so what Felicity did here was go back to the sign-in log, and she found dates on which she had visited the detention center. And so she said, well, those are the dates I met with the client. But as the logs were all being compared and it was clear who she was actually meeting with on those dates, it just became a lie upon a lie. So it became obvious that she hadn't done so. I'm checking to make sure I don't give away the answer. I'm not going to turn the next slide yet. Okay. All right. So what obligations is it, in a general sense, are we dealing with here? Okay, somebody said candor, right? Yeah. So definitely candor. What about related to Mr. Cam's case? What do we have here? We have a forged legal document, right? We have a filed declaration that this client did not sign because he's never met the woman and he didn't swear the declaration. So we have that problem. What does anybody think about the law firm? So she's an associate in this law firm. Yeah, we'll come back to that when we come to mitigating circumstances. But yeah, it's very interesting that the first lawyer who screwed up contacts the law firm. Senior partner is in, Tahiti or something. So Norma, or Felicity, is it Felicity? I forget who. Norma, no, it was Norma at that point, yeah, I forget. Whoever the junior gets the case, and then later they say, it really wasn't our case. It was just her case and we were assisting. Which became a factor because it turns out, Felicity she's a brand new lawyer, as it turns out. So one of the mitigating circumstances was her extreme inexperience in the practice of law and lack of selfish motive, lack of any financial benefit. Those were also, by the way, potential mitigating circumstances in the case I just told you about. They were decisive circumstances in the case of the junior associate who forged the notary seal in experience. So the recommendation was disbarment, or I guess that was the presumptive sanction because of the nature of the misrepresentation, but the board recommended disbarment 8-1, and the Supreme Court affirmed. This was another case I think was really hard, and in part, one of the things we have to do when we oppose the level of discipline is not simply determine what the violation is. That's just step one. But in determining what the appropriate sanction is, we have to conduct what's known as a proportionality review. So we have to look at similar cases involving similar discipline and see what has happened in other cases. And the cases in this area where someone has screwed up and engages in lies or forges things to cover up that screw up, they're kind of all over the map. I mean, I mentioned they run from a 6-month suspension to full disbarment. And I find it really difficult to discern a consistent thread through those cases, which span many years.
But it seems like an aggravating factor in this case is that she continued after.
Yeah, so the comment was, is it an aggravating factor that in this case she continued to lie? There were many opportunities to come clean, which didn't happen here. And that was definitely a factor. Yeah. And, misrepresentation, in court documents to a tribunal is more serious than just lying without being under oath when you lie. Even in the discipline system, those are regarded as more serious. All right, I want to get to the last few. So this is Stephen Sticky Fingers, who liked to take advance payments from his clients. And he described these in the paperwork as retainers, but there was no explanation of how he defined that word. And sometimes he put these payments into his general account rather than a client trust account, even though his written agreements said that he would bill the clients before he would withdraw any of the money out of the trust account. But that when funds were needed from the trust account, in fact, he was just kind of using the trust account and then reimbursing it from the general account and going back and forth. He kept his own handwritten registers. As you might imagine, they were not always complete, and his accounting practices were unique, and occasionally resulted in some overdrafts from the trust account. Sorry, I just want to make sure I'm not giving away the answer yet. Okay. So there were some overdraft notices, and then the WSBA began, again, a targeted audit of his account to see about discrepancies. And in the course of that audit, they requested some explanations and documents. And in response, he explained that he just committed some simple math errors and gave the WSBA his client ledgers and like ending balances. He had actually doctored those. So even though he kept handwritten ledgers, he knew how to use a computer, as it turns out. And so some of those documents were cut and pasted to look like bank account statements, but they were absolutely false, and others were pretty incomplete. Okay, so that's the circumstance. All right, so we know what he did wrong. That's no surprise. This is just client fund mismanagement. I mentioned that's the most common thing that happens in bar discipline cases. What do we think the presumptive sanction for something like this ought to be? Is this disbarable?
Yes.
What makes it disbarable?
He's dishonest.
Yeah. Yeah, and it's solely that. And that's one of the reasons I highlight this case, is this is one of those where what he did should not have gotten him disbarred. He should have been suspended. It probably would have been a 6-month suspension, because there was reimbursement going on. It's like that other case I showed you, which I think was a 6-month suspension, where the client was reimbursed, the money was never stolen, it was just sloppy. But the lying and providing false documents in response to a discipline matter will just pretty much always get you disbarred. Because, and I wrote a fairly well-known case on this, disbarring a person who then ran against me the last time I ran for office, because, and what we explained in that decision, which was not a unanimous decision, this is a tough issue for the court, but what we explained is that the integrity of the whole system, and by extension the integrity of our profession, turns on the willingness of people to cooperate in this system. And once you show that you're willing to lie or be non-cooperative entirely, I have to say in my case, the person, it's the John Zamboni Scannell, whose decision I wrote. There was no lying in that case. It was just gross non-cooperation. But that because of the integrity of the proceeding, and here lying to the discipline, in the discipline investigation is what resulted in this disbarment. And I think it's such a shame. You know, this was just simple mismanagement that didn't have to go this far, but the cover-up is what got the person in trouble. All right. This is not a Washington case. So Cal Kacha was a celebrated defense lawyer, but he had a history of being pretty rough on his trial opponents. So during a recess in one trial, there was an expert witness who just remained in the courtroom, and the expert witness saw Cal walk over to the prosecutor's table and just remove a piece of paper. They all come back into court later, and the prosecutor, who was a younger attorney, said, I have this little cheat sheet, you know, that's laminated, and it's what it tells me all the evidentiary objections, so I make sure I I don't miss him and I can't find my little cheat sheet. And Cal's like, I don't know what you're talking about. And so the witness says, excuse me, Judge, but while we were on recess, I did see Mr. Kacha go over to the table. I don't know what he did, but I did see him go over to the table. Well, wouldn't you know it, they have cameras that run all the time. And I don't want to forget to give that back. And so there's this great video of this whole thing happening on camera. So he eventually like pretty quickly, not in the discipline procedure, but when the judge like plays the video and says, is that you? What's that in your hand? He comes clean and says, oh, for Pete's sake, who needs a cheat sheet with a loser, or whatever he tries to come up with. All right, so this sounds kind of similar to some other stuff we saw. What do you think ought to happen to Cal Kacha? All right, let's see how hard-nosed you all are. Who thinks he should be disbarred? Okay, well, good. Oh, if you do, all right, you're taking him down. Okay. I haven't sold him. I haven't made him look very sympathetic, but a few would disbar him. What about a suspension? Yeah. Okay. What about something lesser, an admonishment, or yeah? Okay. Well, you belong in California because the hearing officer just recommended admonishment. It says this is sophomoric behavior, but on review, they have a different system. They have 3 judge panels. They call it the California Bar Court, and the appellate panel sits in they're designated to that bar court. They imposed a 60-day suspension, emphasizing that he made false statements to the court. He did come clean eventually, but he initially lied to the court. I have to say, I think in Washington, based on seeing the range of similar cases where there were misrepresentations, even when the person, before it got out of hand, admitted, I think that would be a 6-month suspension in Washington. I think that would be pretty proportionate to what I've seen in other cases. So from my perspective, this was pretty lenient when I saw this in the circular that I get. But I also thought it was a funny case, just to remind people cameras are running. You might want to be here. All right, the last case we're going to talk about, and then we'll do some Q&A, is one I just added. This is the only case in your materials that was not a full hearing in the Supreme Court. So this was a matter that was just a discipline. It was a stipulated hearing that the court didn't have a problem with. But let's describe this person. So Becky Bluster had several matters pending in federal court, always plaintiffing these matters, and filed pleadings that were described as voluminous, redundant, and behemoth. One motion was 38 pages long, including 10 pages for the title of the motion. The court described it as a waste of paper, kilobytes, and time. Judges and litigants in several of the cases that Becky was involved in had filed grievances against her with the WISBA, and they cited instances of abusive pleadings dating back several years. I gotta see if I can show you the next slide or if I give it away. Yeah, so I've read some of these pleadings, and they are long, I will say that. The sentences in many instances run on for pages and pages. And in a way that only federal judges write, especially federal trial judges, they have a certain style about them, and they feel a certain freedom to write in a pretty acerbic style. And so there were, sanctions imposed against this lawyer for just writing indecipherable sentences. That one judge said, I don't have any idea what you're asking for. My law clerks can't figure out what you're asking for. The other side doesn't know what you're asking for. This is making us crazy, and you're wasting our time. So I use this example because we see some stuff like this. And I think, in fact, I wish Theo Myrie were here. It's like, it's kind of an exhibit for legal writing, that writing really bad stuff can get you in trouble. And in this case, I changed the gender of this person just to make it just because they were all men for the most part, but it was a man, as it turns out. But this lawyer stipulated to an 18-month suspension. And what the court, which is pretty darn serious for just filing stuff, but you just have to see the history. You can read this discipline notice, you see it's fairly recent. The problem was that it was multiple cases in state and federal court, the same pattern, and multiple patterns of being sanctioned or admonished by the court to fix it. So the court found that based on that pattern, it was intentionally abusive and attempt to harass the opposing side. So this falls under the rubric not of just bad lawyering, but of fairness to the opposing party, of delay, vexatious litigation, so wasting the court's time. Not so much candor to the court, but just vexatious, wasteful litigation. But I just, so that one's brand new. I think that's a pretty serious sanction. I wonder what that case would have resulted in if we had to compare it to others, because cases that are published that involve just bad pleadings and delay in litigation, would maybe be more in the 6-month range. But I think because of the pattern here, this was aggravated. From what I can tell, this again was stipulated. I think there was at least one prior discipline, and that's always an aggravator too, if an attorney is being disciplined a subsequent time.
He's been a lawyer for a long time.
Right, yeah, you look at the bar number. This was so this is so interesting because when you look at mitigating and aggravating circumstances, I mentioned there are American Bar Association guidelines, and they list all of these. Significant experience in the practice of law is generally an aggravating circumstance that you ought to know better. Inexperience in the practice of law is generally a mitigating circumstance. I don't know where you're just kind of a middle child. There don't appear to be any cases where it's like, well, you're not that young, you're not that old. So there's just no middle-aged norm. It's anytime you ever see experience in a case, it's an either up or down kind of thing. Similarly with discipline history. So having prior discipline history is a pretty significant aggravating circumstance, and having no prior discipline history can be a moderately mitigating circumstance. But having a little bit of history doesn't really help us. It's just a feely thing. You just decide, well, this person really ought to know better because of several repeats, or, well, their prior discipline was just for, just an admonishment for taking a laminated card off of somebody's, something like that. So I guess my conclusion from this is that attorney discipline is not an exact science. And I think just as you see many litigants in your courtroom and when you think you need to push or when you need to back off, you have a feeling about the behavior. I think the attorney discipline system reflects similarly. The hearing officer is going to have a feeling about the case. The board on review is going to have a feeling about the case. And the Supreme Court is going to have a feeling about the case. And I'll say at some level, true confession here, at some level that really bothers me, because we're all possessed of our own particular implicit biases. And we're going to be somewhat sympathetic to people that we identify with, and perhaps not at all sympathetic to people we don't identify with. And so it worries me that these cases are squishy in that sense. On the other hand, I'm not sure how else it could be, because these are, after all, human endeavors. And I have some trust that if we look at the cases over the range of time, we can try to find patterns to know how courts are enforcing certain issues. But I think my takeaway when I see these cases is, for the most part, I think that we're doing a decent job in the discipline system of addressing people who are a real public menace, right? And dealing with protecting clients and the integrity of the profession. I think we're doing a pretty good job on that. the trade-off is there are times when I think we're taking cases that don't really have a huge impact on either the individual client in the case or on the public interest, and we're dealing with those somewhat harshly in situations when I'm aware that we have very limited resources for lawyer assistance. You know, the lawyer assistance program in Washington is not particularly robust. And, you know, we have a lot of people, I mean, the unfortunate thing about our profession, and there's decent research that traces it to the way we train and the way we work, not to just who we are, but that we're adding to this, that we have a lot of people with some severe issues, you know. I don't know if you've all seen, I'm ending on a real downer note here, but there's some data from just a few years ago. I think the most recent I had seen is from 2015 about self-reported rates of drug and alcohol abuse problems. And in the general population for women, this is the one I particularly paid attention to, about 25% of women in the general population will self-report that they think they have a significant issue with drugs or alcohol. Close to 70% of women in the legal profession self-report that they think they have a significant issue. And similarly with men, a higher percentage of male lawyers will say that than men in the general population, but that report is higher generally for men. But you know, it's pretty startling. We also see people, I mean, you think about what law school rewards and what the profession rewards. We don't tend to reward work-life balance. We don't tend to reward even-keeled personalities. So we do tend to highlight some people with borderline personality. And so I think that's part of why, you know, a lot of what we see in discipline, I think we could do a better job generally and systemically in trying to take care of problems before they become problems. And you know, you may not know this about my background, but I taught at Gonzaga Law School for about 12 years, and I think a lot about legal education, and I do think we do nothing really to train people about the practice of law as an occupation and as a business. And so it's not a surprise to me at all that the biggest thing that gets people into trouble is just time management and financial management and you know, all of that stuff that I think we do a better job of training with. But I have to say I enjoy doing this. I mean, I'm glad I have to do this. I think it makes me much more aware of what's going on. I hope you learned a little something about what we see. I wanted to provide you with all the materials that we have to date. And I want to give credit to Justice Susan Owens, who first started compiling the cases in a document, and then we all just kind of take turns adding to it, so that we have a running history of these things that we can share with you. And you know, the answer key is there to tell you at least the ultimate result. It doesn't obviously give you the analysis, but you have the cites to all the cases there too. All right, so I have time for a few questions, and I'm happy to take them. Yes, sir.
Yeah, I practiced in private practice in both Oregon and here. And one of the big differences between here in Oregon is the professional liability fund.
Mm-hmm.
And I found, you know, as an attorney in practice, it was such a great resource to have that because there the bar is actually giving you a kind of a heads up or giving you a resource to even prevent this kind of stuff from happening.
Right, and you're talking, so in Oregon, I know that as a part of your licensure, there's some minimal malpractice insurance that's provided, and all the loss prevention kind of services that go along with having a carrier can be provided. So just this morning, just before, or actually at noon today, the court met with the leadership and the regulatory council for the state bar. And there's two things you should be aware of that the bar is looking at right now. One is a mandatory malpractice insurance system, and looking at whether we can reorganize in a way that as a component of the bar license, there's some level of protection, and then the privately purchased insurance might be like a secondary coverage, which I think most people would want, but at least there'd be that minimal coverage. There's a lot that goes into thinking about that, and a lot of people, frankly, I should say, who don't think the Oregon coverage is adequate. So they worry that it's not the model we want to strive for because we'd like to try to do more. The second thing that's going on right now in rules, they're in the rule drafting phase. Doug Andy, who's the Chief Disciplinary Counsel, will be the primary rule drafter. But as you know, we have limited practice officers. We've had for a long time, we do real estate. And then we have the new triple LTs, who currently, there's like 15 of them, but that's a growing group that can practice in limited way. They're legal technicians. And there are three groups of regulated legal practitioners in Washington. There are LPOs, triple LTs, and lawyers. And so there are 3 different discipline systems currently, and it's not the most efficient. So they're in the process of a review to come up with an integrated system to try to streamline discipline. And that's at least a year away from even being put in front of the Rules Committee. There'll be a chance for people to review that and comment on it. But those are 2 things that are under review. But yeah, I think if we did more on the front end, it could really help. And some states that have really robust lawyer assistance programs, I think could be a model for us as well. You just have to be, it all costs money. Yes?
And the Oregon system does provide a lot of great services, but it's incredibly expensive.
That's what I've heard too, yeah, that the expense is quite high.
And the reason it's expensive is that they self-insure. The professional liability fund was started originally because private insurers would not go into Oregon and insure.
I see, because it was such a small bar.
Unlike
Yeah.
Washington, which has
Right, we have
all
40,000 members
kinds
and a
of-
pretty robust.
yeah,
Yeah,
very
so people didn't
robust.
hear that. The Oregon system, and I've heard this complaint too,
Yeah.
that in terms of the insurance you're getting for the amount you're paying, it's a quite expensive
mandatory
plan.
$3,600 a year. Right
Is
now.
it 3,600? Okay, yeah, so.
Mandatory.
Yeah, so, but I just want you to know that Washington, the Bar Association is actively looking, I think we have some buying power in Washington, at whether a kind of risk pool type of arrangement might work in Washington. I saw someone over here, yes?
I would like to know how we justify it readmitting people to the bar who have been previously disbarred for ripping off a client,
Sure.
being dishonest. Why are they allowed to be readmitted?
Yeah, so the question is, how do we justify allowing the readmission of people who've been disbarred for, ripping off a client or lying to a court, et cetera? I think there is a justification, and I think it's, the eternal hope and redemption at an esoteric level, but the requirement that simply because of misconduct in the past, if there can be shown rehabilitation, so they have to demonstrate what they've done that shows that it can't just be the passage of time, and that there's some assurance that they're reformed and that it's not, similar conduct's not going to happen again and they would be a valuable member. That's the basis for the readmission. And I think it also has something to do with, again, bear in mind that we're a self-regulated organization. We let people join the bar who've been convicted of serious crimes. We get character and fitness reviews all the time where someone's gone to prison for dodging the draft, or the very famous student at University of Washington who was admitted a couple years ago, who was a bank robber and published a book, and he's a Gates scholar. So, I think that's the rationale. So I'll just attribute it to the eternal hope and redemption. Yes?
If someone chooses to resign in lieu of disbarment, do they wait a 5-year period, or do they then go through the process?
Oh, that's a good question. So the question is, if someone resigns in lieu of disbarment, how does that
And if they want to be
process work? I should know the answer to this, and I don't. But I'm not recalling that there's a difference. Because again, nobody gets an automatic review after 5 years. If they want to reapply, they have to go through the whole process. And I think I'm not aware that, I can't, we don't see the voluntary disbarments when those are approved. I mean, we don't necessarily see the whole document. And I'm not aware of anybody ever saying a condition of us doing this is that you will never reapply again. But I actually just don't know the answer to that question. Sorry. Yes.
When you're suspended, do you have to reapply to the bar at the end of your suspension, or are you automatically?
No, that's the difference between disbarment and suspension. So a suspension really is a time that you are not allowed to practice law whatsoever. But once that time finishes, then you're reinstated, but subject to you doing everything else. You need to have been paying your dues and your CLEs, and everything has to be current in that regard. It's very common, we do reciprocal discipline, so it's very common people practice in both Oregon and Washington, or California or Idaho, and if they are suspended in the other jurisdiction, we will do a reciprocal suspension most of the time. And it's not uncommon that we'll look at the period of time. So we might suspend someone, but make it, we might delay it a few months so that it matches, or make it retroactive so that it matches. But you do come back in after the suspension, assuming your other conditions are met. In the back.
So when there's a requirement that you have a mental health evaluation before being readmitted, how is that reviewed by the court? And do you impose that separately sometimes, or is that something that comes out of the bar association?
Yeah, so the question is, what if someone has like a mental health evaluation or some other medical requirement? How do we look at that? The court has imposed monitoring conditions, and we've certainly endorsed. Let me back up and tell you this. When someone comes into the discipline system and they appear to have a medical issue, a mental health issue or other medical issue, there are separate tracks, and the bar will try to have them convert that into a disability proceeding, which makes a lot of what goes on confidential as well to protect their health care privacy. And then a lot of services can be coordinated through that. In our view, that's the best outcome when someone's experiencing those issues. So that's coordinated with the bar. They're also appointed counsel in a disability proceeding. When they're going through the normal discipline proceeding and they're not entitled to counsel, they might negotiate, well, you have to get drug and alcohol counseling or do some other mental health treatment. What we've done as a court is not impose that, but we've endorsed that, saying that that's a condition the bar imposed, and we will insist upon that. But we've also insisted on monitoring in certain instances where someone will be suspended maybe for 2 years, and then upon reinstatement they have to co-counsel, they have to have someone who's agreeing to supervise them for that period of time. And that's again for public safety. And we've actually had cases in which the person who agreed to supervise someone has himself gotten in trouble for not doing a good job. And you're signing on to be responsible, and they haven't done what they said they would do, and they get dragged into the same problems that the discipline attorney was in. Yeah, so we have seen that happen. So it's a huge responsibility. If someone says, I'm going to monitor so-and-so, that's a pretty huge responsibility. Yeah, probably last question.
Okay, in an administrative hearing, people can be represented by anybody as
Right.
choosing whether they're an attorney or not. And I think it's come up a couple of times with disbarred attorneys representing people in administrative hearings. As an administrative law judge, how do you deal with that?
Yeah, that's interesting. So to me, the question is about disbarred attorneys representing people in administrative hearings, because one doesn't need to be an attorney. I don't have any concrete advice on how to deal with that. To me, that's up to the rules of the administrative tribunal. If you don't have to be a lawyer, and the person is not a lawyer, they're disbarred, I think that's up to the particular office of how they'd want to allow that. That would never come to us because they're not practicing law in that situation. I was thinking you were going to ask, we've seen many cases where someone's done a really good job at an administrative hearing and then they can't argue the appeal, on behalf of the citizen group or whatever. Like, shoot, the best advocate in the case can't argue in front of us. But but that to me is an issue of what the rules are for advocating on behalf of somebody else in the administrative setting. Yeah.
But should an administrative law judge verify that the client actually
So if the issue is, does the client think this person is a lawyer? Is this person holding himself out as a lawyer? That's separately subject to discipline. And I hope if you ever see that you will report that, because that's yeah, that, I was thinking you were just describing, everybody knows the person's disbarred, they're simply continuing. There's some fairly notorious disbarred members of the legal community who represent people frequently in in settings, I mean, represent, not as a lawyer, but who advocate for people in administrative settings. And that's just not an issue that implicates discipline. Thank you all, I appreciate the opportunity.